then we'll make that available for her and for any of you who want to go back and review. I know that we get some really high quality things from our judges, and so that's great to be able to go back and say, I didn't quite get that. I want to learn that again. So we'll go ahead and get started. And I want to thank both Judge Craigs and Mr. Rojas for helping us this afternoon, sharing your expertise. And I've been looking forward to this, to learning. I know when we go through certification, the training they give us on calculating child support is very short. Mostly it is, here is the form tonight for homework, fill it out and hand it back in tomorrow. And that is the extent. So our mediators do a lot of reading, but I know they're looking forward to hearing your expertise and your um, excuse me, your knowledge from the bench also. So, Judge Craigs, do you need to be made co-host so that you can share video or anything?
Actually, the very first thing that I want to do is to thank Mr. Rojas, Child Support Hearing Officer Rojas, because he is the technology guy in this presentation. In addition to his substantive knowledge, he is in charge of technology. That was the smartest decision that I made when preparing for this presentation. And so I think Mr. Rojas will need to be made co-host, and he can put the it's not a PowerPoint, although I think that word is sort of like Kleenex. He will put the PowerPoint or the is it called Prezi, Mr. Rojas?
What it's called. It's a presentation that's a little bit more interactive than PowerPoint, and I hope you all enjoy it. And I hope you should be able to see it now.
Yes.
Yes.
And can everyone hear us okay before we get too far into the presentation?
Yes.
Yes.
Okay, good. Good. All right. Thank you for having us. It was one of those things where I was like, sure, I'll be glad to do the presentation. And then when it came time to put the work into it, I was like, scrambling around. And I think Mr. Rojas thought I would never get prepared, but hopefully we won't disappoint you all today. The one thing I will tell all the mediators that are joined us today is just how important child support calculations are. And there's much of it that is very specifically statutorily driven and rule driven and mandatory and things like that. And so when you are working on child support during your mediations, just know how much the judges and the general magistrates depend on that. I think we all know what child support is. The one thing I'll just say from the very beginning, because I think sometimes parents, especially obligors, don't particularly enjoy sending child support to their former spouse or co-parent, is that child support is a right of the child. It is, you are not, yes, you're sending the money to another adult, sort of for obvious reasons, but for those of you mediators who meet resistance from the parties about having to pay money to their former partner, it is a right of the child. And that's why judges have the ability to reject agreements that, if properly pled, child support is waived in some form or fashion. We have the right to overrule that. And I don't want to get too far ahead and start covering things that are later in the presentation, but child support is a big deal. So try to impress that upon the folks that you have in front of you mediating their cases.
Sometimes one of the things, Judge Craigs, that I also see in regards to that it is a right of the child. It is paid to the person taking care of the child, which may be a relative or maybe the mother or the father of the child. Sometimes parents think they can give petty cash to the child or they can pay that directly to the child. That's not how child support works, because it is to provide for that child while the person has the majority of the time with that child or the majority of the resources.
And maybe one thing that you all have heard before, and the child support guidelines haven't been updated for a long, long time, but the way those were calculated were a bunch of economists and smart people got together, and it's actually the percentage of living expenses that they attribute to the child or to the children. It is a portion of the mortgage. It is a portion of the car insurance. It's a portion of the gasoline. And so that child support guideline table took all of that into consideration. And I would have to assume that pretty soon they will update their study, for lack of a better way to put it. But that's just a tiny little bit of general information about where those numbers came from. All right, next slide. All right, so the interaction or interrelationship between alimony and child support, it is important because alimony is income. And so before you run your guideline child support calculations just based on W-2 income or employment income, you need to know if one of those two parents is paying the other one alimony. Just a few little tidbits of information. Again, if you already know this, accept my apologies, but we don't have permanent alimony anymore. So know that. Also, it has been, I was surprised when I reminded myself of this date. Alimony is no longer taxable deductible. It used to be our child support programs would tax effect the income to the recipient and the deduction to the obligor, but since 2019, the tax code changed that it was taxable deductible. It's income, it's just not taxable deductible. And so that's why we do things in a particular order in family law. The PEACE acronym, parenting first, because we need to know the number of overnights and time sharing. And I'm gearing this talking about child support. Equitable distribution, you could have an income producing asset, some rental houses that produce income. So that's why we do equitable distribution. Next, alimony. Because again, alimony can be income. That's why we do that next. And then child support, so that we have figured out the overnights, the whether or not any of the equitable distribution is income producing, who's going to get that income, and the same thing for alimony. So make sure that you try to organize the parties in that fashion. And if you can always just use the PEACE acronym. And I guess I should say the E is everything else, who's going to claim the dependency exemption when we look at that from a child support standpoint. Math is hard. There are some tools that can be very helpful to you. I constantly am recommending the Florida Supreme Court approved forms to people, including, the financial affidavit. If you all will look at page 3 of the instructions, it is the handiest, most well-organized chart for how you take hourly income and convert that to monthly, daily, weekly, bi-weekly, semi-monthly. It's right there for you because it's not the same. Getting paid 26 times a year is twice a month is different than getting paid every 2 weeks, and it will make a difference in your calculations. So I commend to you page 3 of the financial affidavit instructions, and you can just print that off and put that in your mediator toolbox for yourselves. Go ahead, Mr. Rojas, please. Calculating child support. It's a formula. It is a statutory formula. 61.30, Florida statute 61.30 provides you with that formula. If you just look at your financial, when I say yours, meaning the ones you have in front of you, the parties' financial affidavits, you'll see all the various different categories of income There's really 14 plus some lines for things that they didn't include, but it's tips and bonuses and business income. It is disability benefits, work comp, unemployment, pension, retirement or annuity payments, Social Security, alimony, interest and dividends, rental income, your gross receipts minus the expenses to produce that rental income. And then also another one that might sometimes get overlooked is in-kind income. That's line 13, monthly reimbursed expenses and in-kind payments to the extent they reduce your personal living expenses. Your employer pays for your gasoline, your cell phone. You're a horse farm employee or manager and you get your housing as part of your employment. Different things like that. All goes into gross income. Also, if you all look at section 61.046 of the Florida statutes, it's the definitions section of the dissolution of marriage chapter. It defines income in subsection 8. It defines obligee. It defines obligor. And again, if you're building kind of your mediator toolkit for child support, it's probably a good idea to have that those definitions handy for people who are unclear. I want to stop myself for just a minute because I wrote this note down. So many of the judgments, mediation agreements that we get, reports and recommendations from general magistrates say no child support. It's always a great idea to look at your pleadings. And that's what I do. When I see that, the first thing I do is go to the petition to see, did they plead for child support? Because if they're in mediation wanting to talk about child support and it's not pled, then there almost needs to be another conversation about whether or not they're going to amend their pleadings or something along those lines. So just always remember before you take a bunch of time working on this to make sure that child support was pled. Because if it wasn't pled, that's an issue. And if it was pled and there's an agreement that they're not going to exchange child support, we still have to have that mandatory child support guideline worksheet in that court file, because I've seen cases where it was waived and guideline child support was over $600 a month, and I wouldn't accept the waiver. If it's $25, if it's $100, and it depends on the circumstance, maybe the other party's going to pay all the travel baseball or all of the uncovered medical. But even if they waive child support, that guideline worksheet is a mandatory non-waivable requirement. And I'll give you that rule a little bit later in the presentation. So gross income, less deductions. We have things like obviously taxes, Medicare, FICA, but there's also mandatory union dues. Being from Florida, I don't think that's as prevalent of an issue as if we might be in a different part of the country. And are they mandatory? Some people voluntarily join a union. That's not a mandatory union due. Mandatory retirement payments. If you have a school teacher or a state employee, that's not too unusual that they may say they have mandatory retirement. But some people contribute more than the mandatory amount. And what is that percentage? Is it 3%? You need to know a little bit about that so that if they're withholding more, that only the mandatory portion is accounted for. Health insurance for the parent. That's not for the whole family. Health insurance payments excluding the portion paid for any minor children of this relationship. You're going to need to know the health insurance expense for the child or the children at a later time in your calculation. Monthly court-ordered child support, monthly court-ordered alimony. That financial affidavit really is helpful to you when you're trying to calculate child support. And then, of course, I mentioned this briefly earlier, but the number of overnights, that's going to be really important to the calculation. A little sidebar, I don't know how many Chapter 751 cases that you all mediate, temporary custody of a minor child by a relative or fictive kin as of a year or two ago. That statute 751.05 subsection 5 talks about child support in those cases. So if you all find yourselves mediating any of those Chapter 751 cases, make sure you are familiar with that statute. All right, Mr. Rojas.
Okay. Is there any questions so far up to this point? I know we've given a lot of information, but is there anything that any of you have any questions in regards to that we have already discussed?
I mean, I've got one that just came up recently, probably in the last, I'd say 2 or 3 of the last mediations I've done, is one or the other is declining to report how much they got in tips, because their opinion is it's not going to be federally reported, so it doesn't need to apply in this instance.
And this goes right into the next subject that I'm going to be discussing, which is the willful unemployment and a little bit into the imputation of income. So I'm going to go into that subject and describe that a little bit. So
Thank you.
parents are presumed to be able to work, and their disability must be proven. You probably heard someone saying, I can't work, or at mediation, or I haven't worked for some time. But really, the law presumes that they're able to work unless they prove otherwise, okay? So if they're capable of working, they should be able to, you should be able to find some income. Now, for this type of imputation of income, the first thing you try to go to is their most recent employment history. So you may have it in the affidavit. They might have given you that information. They were employed 3 months ago and they were making about $3,500 a month. Great, that was the most recent employment. You may ask them, is there any reason why you're not going to be making $3,500 a month when you find employment? And, you know, are you actively looking for employment? And is there any reason you're not? And if they're not, that will be a great basis to impute the income if you have that information of very recent employment. If you don't have that information and you determine that the parent, you know, is not disabled, an easy question is, you know, is there anything preventing you from getting a full-time employment at minimum wage? Because many parents, they may not have any employment history for the past 4 or 5 years. But there's nothing preventing them. They just have chosen to stay at home and care for a child, but still they're presumed to be able to at least be able to work a minimum job. Now that amount, as of this year, which that changes on September 1st of 2025, but as of this year is $2,253.33 as of the minimum wage right now. Now there is that thing of imputing median income. I spoke with the judge about this, and it used to be a little bit easier to find it. The Census Bureau has the information in there as far as, you know, for location, for household, for the number of members in the household. And we will include a link and send you a link to be able to access that information. But it will take a minute to look at that information. Let me just calm you in regards to that, because median income is something more used by the courts that we impute when the parents have actually refused to engage in the discovery process. They haven't provided any financial affidavits. They haven't provided anything to the court to be able to get an income. And median income can be imputed under those circumstances. And that's mostly the cases where it's imputed. But if you have to look for it, there's a way of looking for it, and we will provide that information. We'll send an email to Mary Ann about that. Judge Cracks, is there anything I'm missing in regards to this?
I would say two things. For someone to not be employed, it's that they have that they're physically capable and emotionally capable. Those are the criteria. There's also some instances where taking care of a child at home is or going to school or reasons why you don't necessarily have to be employed. But in cases that we have that I agree with Mr. Rojas, it happens a little bit more with the court than it does with the Department of Revenue. Cases that he hears are people that just are digging their heels in and do not want to share their income information. I mean, we have jurisdiction, they've been served, and they're just not going to participate. And what the statute says, and this is 61.30 subsection 2B, is if the information concerning a parent's income is unavailable, a parent fails to participate in a child support proceeding, or a parent fails to supply adequate financial information in a child support proceeding, income shall be automatically imputed to the parent. There is a rebuttable presumption that the parent has income equivalent to the median income, and that's MEDIAN, income of year-round full-time workers as derived from the current population reports or replacement reports published by the U.S. Bureau of the Census. And again, I do have a link that I will send to you, but it's not a small number. Mr. Rojas, I think you knew the number for Marion County. What was that approximately?
It's
50 some? Yeah.
$58,608, which is not something, for example, that we would impute to someone making tips at a restaurant. Where in a case like that, I mean, and it depends on the circumstances, right? But in a case like that, it would seem more appropriate, the minimum wage, because if at least minimum wage they're making with the tips, if they're completely unable to provide that information about how much the tips are, it's probably not going to be $60,000. That will not create a equitable result in that circumstance. So,
However,
yes.
Mr. Bush, that may be helpful as a mediator to say to the person, you may want to reconsider providing the information that you have, because if you refuse to provide that information, there is a statute that says that there's a rebuttable presumption, and somebody has to rebut that. The court does not rebut that presumption. They
Right.
have to rebut that presumption that it is the median income of a full-time worker. And so when they hear $58,000 or $55,000, there's some different numbers in there. They may decide that they don't want to play coy and tell you that they're not going to tell you their income. That is not conducive or helpful to resolving the case either on an agreed upon basis at mediation, or if they can't agree, ultimately in the courtroom. And so if a party believes that they can skew the outcome or direct the outcome by simply crossing their arms and saying, I'm not going to give you that information, that may not work out really great for them in the end. And, and as a mediator, which I used to be a long time ago, maybe the mediation way to approach that is simply, hey, we're here to try to settle the case. And if both of you aren't going to put all your cards on the table for us to be able to run these super important calculations, then the chances of settling at mediation are going to go down. And I'm not trying to worry you unnecessarily, but there are ways for income to be imputed to you that may be more than you than you earn, which isn't going to help you.
Okay, thank you.
Agreed. And you know, one of those, giving them that information about the median income will probably entice some of them to provide the actual information, which will be more helpful for them. So,
And we will send you this link to the census, because as you might imagine, there's more information there than you would ever want to know. I assure you, it's a little bit cumbersome, to say the least. Okay, step down calculations. Another mandatory part of Chapter 61 for the calculation of child support is that if there's more than one child, that not only the current calculation, guideline child support calculation needs to be run, but the one after the oldest child emancipates also needs to be run. And 61.13 subsection 1A, 1A, B, and C says that child support orders must provide for child to terminate on the child's 18th birthday unless they're enrolled in high school, proceeding with a reasonable probability to graduate high school before they turn 19. There's also the other things that cause child support to terminate: marriage, entry into the military, full-time job, and they're self-supporting. And the agreement will need to provide that when the oldest child turns 18, again, unless they're going to graduate high school before they turn 19, that child support for, if there's 2 kids, child support for 1 child is going to be X. And then it needs to also go on to say, when that child turns 18, child support will terminate again unless they're still in high school. And that's the very, very beginning of Chapter 61.13. Also, this is, I told you I was wanting to tell you that also, these guideline child support worksheets are mandatory. That is Florida Family Law Rule of Procedure 12.285 subsection K. The case will get reversed on appeal if that worksheet is not in there. And there's plenty of case law to that effect, and that's even if they decide to waive it. Now, if they didn't plead it, that's a different situation. But if it's pled and they've decided that they're not going to exchange child support, that calculation still has to be there so the judge or whomever can look at that to say, okay, you know, either I need to ask these parents, are you sure you can take care of the child when you have the child without child support that you were to receive? The other thing is, oftentimes you'll see a settlement agreement where child support is waived or is a certain amount. And then the judges say, file your worksheet. We're not going to give you a final hearing until the worksheet's in the file. Then you see the worksheet and it's a pretty nice child support amount, but the person has already settled the case without that information. Judges do have discretion to not accept a waiver of child support. Another little thing that I bet you all already know, 50-50 timesharing doesn't mean no child support. And the best simple example I can give you is one parent makes $150,000 a year. That's probably too high of a number, but and the other parent makes $30,000 a year. So they have the kids equal time, but their incomes are not equal. And the person who makes 5 times amount of child support is going to owe child support even if they have 50-50 timesharing. So don't let your brain jump ahead and say 50-50 timesharing equals 0 child support. Okay, next slide, and it's your turn, Mr.
And a couple
Rojas.
of things in regards to this. It used to be that step downs did not have to be allocated. And sometimes parents may come to mediation saying, well, we have 3 kids, so we're going to do $800 for child support, and they want to reduce that to writing. Well, the statute requires that you do a step down because The obligation, if you have 3 children, will not be a third less for the second child and 2/3 less for the third child. It does not work like that when you run the calculations. So they need to actually be run.
It's a good point.
Wow.
Thank you.
In regards to the incarcerated parents and child support, we're in a very interesting situation in Florida because in our circuit, the Fifth Circuit, there's case law out there. There's the Wilkerson case that states that child support should be established and could be established against an incarcerated parent. There's also case law there that states that it is not an abuse of discretion to impute minimum wage upon an incarcerated parent. And some case law that explains that when a parent is incarcerated, that may be used as a deviation, and that is the DOR B Baker, I believe, B Jackson, Department of Revenue versus Jackson, 846 Southern 2nd 486, which basically states that the incarceration could be used as a basis to modify the obligation, and the obligation may be held in abeyance until the parent is incarcerated and brought to the attention of the court for that modification to actually take place and for the arrearages to be repaid. The statute says that Chapter 61 says that the incarceration of a parent may not be used as proof of voluntary underemployment. So, and we don't know how that is going to be interpreted because that was a change in 2023. Okay. So the gist of it in this type of cases is if you're in mediation with an incarcerated parent, generally the case law will support an agreement as to minimum wage in those circumstances until there's other case law in our circuit that says otherwise. But that's what the case law is right now, that it would not be an abuse of discretion if minimum wage is imputed. Now you're working with mediation, so that's something we will probably see in the decision type, not the mediation setting. But they know that they can expect that something will be imputed, because what happens is in I think it was 2019, the legislature, there was some proposal that was brought to the legislature to suspend child support while a parent was incarcerated. What that will be the equivalent to is to basically impose the burden of that incarceration on the child. And it's not the child's fault that the parent became incarcerated. So the legislator refused to do that. So that's basically been the position of the courts and the legislature for the past few years. Anything I may be missing in regards to that, Judge?
No, I don't think so. As is sometimes the case, this next slide about calculating child support without financial information, we've hit on pretty hard already. This was where we were talking about the median income of a year-round full-time worker. You can find that information again in section 61.30 subsection 1B. And imputation of income is a directive. It's not permissive. It's shall, if that unemployment or underemployment is found to be voluntary, absent a finding of physical or mental incapacity. I think I said emotional earlier. The actual language of the statute is physical or mental incapacity. And then it tells you what to do. It's handy. Recent work history, occupational qualifications, and prevailing earnings in the community. And then we get to if you're just not going to participate, and we have jurisdiction, we get to this census information that we talked about, and that is the link that I will get to you all as a follow-up to today's presentation. There is a lot of case law out there about imputing income. I will tell you also that there's a lot of case law out there that somebody says they make X dollars and you only have to go a very short distance in their financial affidavit to see that their rent and their car payment exceeds their income. And that may provoke some dialogue or some inquiry about how that could be. And if they have been fired, that can be determined to be, voluntary. If they leave their job to pursue educational enhancement, some cases say if the child is young enough and the child will benefit from the increased income from the new educational qualifications, that's not voluntary under or unemployment. They want to start their own business. You apply a test to them, and that two prong test, if you will, applies to pretty much all situations. And the court has to make findings. And so if the court has to make those findings, it's perhaps fair game to discuss as a mediator of, if you don't settle your case today, how are you going to prove, that that's your income or that is not your income? And the two-prong test is it voluntary? And then the second part is there is the fact that they're underemployed or unemployed due to less than diligent and bona fide efforts to find employment income at a level equal to or better than their former situation. And they bear the burden of proof. And so if they're having a hard time explaining at mediation, how they find themselves in that situation, they may have trouble proving that in court because they do bear the burden of proof. Mental health issues can be a reason why somebody is under or unemployed. The court can refuse to impute income if a parent's staying home with a child. And so those are just kind of some of the themes, if you will, that we address when we're having trouble figuring out what someone's true income is. And we'll get you that link after today's presentation. All right, Mr. Rojas.
So one of the things that you mentioned, Judge, that I recently had, and we have it from time to time, is these parents of medically needy children that are basically spending 4 or 5 days a week dealing with a GI, Crohn's disease, or some other very involved condition. And they're the caregivers for the child, and they're just unable to work because no one will accommodate their medical appointments for this child. And that's a very common instance that I see a couple times a month, where one of the parents is just, on Medicaid, but they're going from appointment to appointment, and it's just very difficult for them to work. And I was trying to think about a specific example because now what we need to talk about is the health insurance, and you did mention some of that, Judge, in regards to the health insurance costs. It bears upon child support differently. So you need to determine certain things as you're inquiring. Many times the plan, there's different kinds of health insurance. So one of them is where you pay $30 for the whole family, depending, you pay an amount, X amount for the whole family, and they don't divide it among the members in any way. It's just like an employment benefit that is for the whole family. You can't tell whether or not it is for one person or 3 people. You can't tell. Under those instances, the easiest back of the envelope calculation is you determine how many people are covered by that insurance, and you give one deduction to that parent that is paying for that insurance. And if that insurance is covering the child subject to the obligation or the children, you give them a credit for those amounts. They go in different categories. So when you run your guidelines, there should be different categories for the child support amount that for the medical insurance they're paying for the child, because that goes into a credit category, just like it is the aftercare costs or daycare costs. Those go into like a credit type of expense that is given directly for the care and well-being of the child. Whereas the other one is a deduction, and it goes into the parents, is taken away from the parents' income. So those two things need to be determined. Many times it's very simple and they have it and it's being deducted, and the family plan is so much and the individual plan is so much. So you will need to determine what the individual amount is, and then the difference that they're paying for the family plan divided amongst the total other people that are covered other than the parent. Any questions in regards to more or less how you do that math? Because I might have mentioned a lot and maybe confuse some of you. Any questions in regards to that? Sometimes they don't come up with the information. Many times what they have is a general number of how much they pay for health insurance. They may come up with a $300 number, and it will not be improper if that's the only information they have for mediation, that's divided among the people covered by that insurance. And that's sometimes that's the best you have for mediation, because you don't call them back to bring the documentation, I would think.
Okay, tax considerations. I think Marianne had mentioned to me that that court mediation uses a different guideline calculator than I use. I use DPA, but the tax considerations, DPA will automatically, if mom has more overnights, it will automatically assign the dependency exemption to the parent, whoever, mom or dad, has the child the bulk of the time. But sometimes people want to negotiate that benefit. And even if mom, in my example, has the child more than dad, perhaps mom has a lot of other dependency exemptions, and the family isn't going to get that much bang for the buck if she claims the child at issue. It can be transferred, but if it is transferred, then your calculation needs to know that and have that information so it can change the withholding. That's what it's going to do, is change the amount of proper withholding. So the other thing, if you do use DPA, just make sure you go into the tax section and you switch that so that it's accurate. There's also child tax credits, and the child tax credit for 2024, I printed some information about that, is $2,000 for every child younger than 17 years of age. This is an IRS concept. It's not necessarily a Florida statute concept. It's an IRS concept. And you can find that information pretty easily on the internet. Now, earned income credit is different. That is a different concept than a child tax credit. Earned income credit is for lower moderate income workers. And as the name implies, you have to have earned income. We don't want to address that topic in mediation if they're not employed. It can be investment income, earned income. You have to have a social security number. You've got to be a U.S. citizen or resident alien, meaning you have not filed a form saying that you have foreign earned income. But in order to, I'm going to just use the word receive the earned income credit, there's a table, and it talks about the number of children or relatives that are being claimed. It asks you to consider whether you're the person's filing as head of household, married filing separate, or widowed, or if they're filing married jointly. And it tells you that you've got to earn under a certain amount of income to receive that earned income credit. On the DPA calculator, that box is the default setting is it's checked. You have to uncheck that box if the person doesn't meet that income criteria. So married jointly, if you have one child, the income has to be less than $56,004, just to give you all an idea. If you have 3 kids, less than 66,800 if you're married joint. If you're single, and you have one child, it's $49,084. So I'm not sure how often this is going to come up, but it is definitely something that you need to be aware of, because it is going to alter your calculations if your program has it checked off or does not have it checked off, and it should be. Parents can negotiate the dependency exemption and some of these things. And so they're free to do that. You just want to make sure your calculation accurately reflects whatever agreement that they reached. All right.
But one of the things in regards to that I've seen in some of the mediated agreements is that they run different guidelines from when they're going to be claiming the children in their taxes. And child support should be constant while that child is a minor child. It shouldn't be changing year by year. So one easy way, if you have one child, for example, that's going to be claimed by one parent 1 year and by the other parent the other year, you may want to run the 2 calculations and split the difference, and just have those 2 guidelines in the court file and explain why you split the difference in those. Because it may make a difference of, $30 to $50 to $100, depending on the tax and how many children are there and how many are being claimed by each parent. So that's something that I've seen.
No, thank you. That's a very, very good point. It's perfectly fine for parties to agree that dad's going to claim the child in odd numbered years and mom's going to claim the child in even numbered years. But you've got to run it with mom claiming, dad claiming. It's going to be a different number. And then take those 2 numbers, add them together, and come up with an average. So as Mr. Rojas said, the child support number is constant, no matter whether it's an odd numbered year or an even numbered year. Thank you for bringing that up.
So one of the things that sometimes comes to our attention is when the parties agree to a lower amount than what the guidelines establish. So you already run your guidelines, you show it to them, it's set $900, and they agree to a $600 amount, which is definitely in excess of 5%. So the statute talks about 5% as a threshold when the court has to justify the finding to deviate from the child support amount. So it is very helpful as you're conducting mediation that if the parents state the reasons what they want to deviate, that is included in your deviation, that you're lowering of the amount, or sometimes they want to increase it because they say, well, child is going to private school or whatever else reason they agree, and they have a reason for that. It'll be very helpful to include it on the mediated agreement, because that will help the judge to see that and be able to support the deviation. Anything in regards to that, Judge, that I may be missing?
No, I think you hit the nail on the head. Judges typically, we don't want to undo what the parties have agreed to, but if it is something unusual or different, but it's explained, then we understand better. We still might ask a question or two, but at least we understand why they chose to do that, and we try to let them have their free will.
I talked about this a little bit earlier. I think I already mentioned this, that the modification because of incarceration is never automatic. And I don't know how in mediation some of these cases may come to you. It may be that they're currently incarcerated, that they're about to become incarcerated, or that they were incarcerated in the past for a portion of that arrearages. So it may affect child support, and you may consider the incarceration as you're mediating and bring that into the mix. But as I mentioned before, it doesn't necessarily mean that the child will not get any child support for that period of time. And it will not be wrong to impute minimum wage if the parties agree within the confines of mediation to do that. Social Security benefits and child support calculations. Well, there are three types of Social Security benefits that are relevant when we talk about child support and Social Security. So there's the Social Security or disability income, which is the Social Security adults receive when they become disabled. They paid into it during their whole lives or during the portion that they were able to work. They got enough credits with the Social Security Administration, and now they get this Social Security disability benefits, which is their income. There's also supplemental security income, which is in the case that the Social Security Administration has determined that someone is unemployable and disabled and in need of assistance. So this is basically like a public assistance benefit for that parent. It is very limited. It's between $700 and $900, so it's not a very large amount. But it may also be considered as income, that amount. It is one of the benefits of the Social Security Administration. And there's also the Social Security or the supplemental security income for children, which is based on their own disability. And those are rarely common. A lot of children get it because if they have a disability that prevents them, or a special needs child, for example, or some other disabled child, they can get this benefits. It's about $700 a month. Be aware that benefit to the child doesn't go anywhere in the guidelines. It doesn't go I mean, there's some spots that you may see where it says child support to the child. If it is a Social Security income received for the child's disability, it doesn't affect child support in any way. It is meant to be a support for that child that has additional special needs, additional medical needs, mental needs, and it is meant to support that parent in caring for that child. Now, there is this thing that if you're receiving Social Security disability income, the one that you paid for while you were able to work, that your child may receive derivative benefits. Now, that word, I always get it. But what it means is that you get benefits, your child gets benefits on your own behalf because you are receiving benefits. So sometimes that is the case, and they may receive a substantial amount of Social Security disability income. Now, that will be credited to the parent that is obligated to pay support, if that is the parent receiving the Social Security disability income. That will be credited to that parent, okay? So that's a little bit of a mouthful there. Do any of you have any questions in regards to Social Security disability specifically and supplemental security income?
Well, I would like to add a little bit to that, Mr. Rojas,
ahead.
but just to give an example, if the parent is receiving Social Security disability, and these examples may be silly when it comes to realistic numbers, but they're receiving $3,000 a month. And because of that parent's disability, the child is receiving $1,000 a month. Whatever that parent's child support obligation is, they will get a credit of $1,000 towards that. Now, let's say their child support wasn't $1,000, that parent only owed $750. The child still keeps the parent who's receiving the money for the child still gets to keep it. The payor parent or the parent with the disability doesn't get a refund or anything like that. But if the child support obligation is not this as much, if it's more than $1,000, then the parent's going to pay the difference. So, I may not have made that very clear. In my head, it was clear, but it didn't seem like it came out very clear. But if a child gets disability benefits because of their disability, it doesn't get included. If the parent gets disability benefits, it's taken into consideration. And just to give you all a few other examples, Veterans Administration disability benefits, that goes into gross income. A parent's non-taxed disability and reemployment assistance payments are part of income. Let's see what else here. Public assistance is not included because public assistance as defined by section 409.2554 shall be excluded from gross income. So it's just not part of the statutory definition. SSDI, we talked about that already. Social Security benefits, are definitely included. And so those are just a few extras maybe that you don't see quite as often.
And
All right,
two
go
things
ahead, Mr. Rojas.
in regards to that, the veterans benefits, they cannot be intercepted by the courts as easily as any other benefits. So an income deduction order does not work the same with the benefits that they receive from the Veterans Administration. And many veterans will come to you saying, oh, this cannot be taken, this cannot be withheld. And that does not mean that they're not considered as income for purposes of establishing the obligation. I do see many of them all the time coming to me, well, but the statute says that it cannot be taken. Well, that doesn't mean it cannot and should not be considered for the child support obligation, and that you're still not going to be required to pay child support, because those benefits are for the benefit of the family of the veteran, not just for the veteran. In regards to benefits like public assistance, TANF, housing assistance, one of the things that make it clear to think about this is that the public policy in Florida is that children will be supported from the income of their parents. So all of these things shouldn't have a bearing on the child support obligation, because of course, if the parent would pay their child support obligation every month, maybe this child will not, and this parent will not need to get food stamps and housing assistance. So that's the way the state of Florida looks at this. Like if the parent was paying child support, maybe we wouldn't need to support these children, and that's how they look at that.
Calculating arrearages. The statutory authority for this is section 61.30, subsection 17, at the very end of that particular statute. And what it provides is that in an initial determination of child support, doesn't matter what kind of a case it is, paternity, divorce, the court has discretion to award child support retroactive to the date when the parents did not reside together in the same household with the child, not to exceed a period of 24 months before the date of filing. When you're looking at, and I know I'm using two different words, retroactive child support and child support arrearages, but the statute uses the word retroactive. You have to use the applicable facts. So if the parties are looking at child support under the day of mediation circumstances, what their incomes are, what time sharing they just agreed to 50-50, that's one thing. But 24 months before that, if they were separated and not living in the same household, maybe the time sharing leading up to mediation wasn't 50-50, who knows what it was, but you have to run the retroactive child support under the then circumstances. What income were they earning then? What was their gross income? Maybe they didn't have health insurance then and they do now. The time sharing was different. Whatever facts and circumstances were at issue, for that period, you've got to calculate retroactive child support using that information. You can't just say, okay, 50-50 time sharing with these incomes and this insurance and this aftercare is $1,000. We're going to use $1,000 back 24 months. And it's aggravating because I've had cases where I have 7 different child support calculations, and you keep running them, and it's not always the most fun thing to do, but you've got to calculate retroactive under the circumstances at that time. And, people with a lot of job changes, there's going to be a lot of calculations. And as I mentioned before, there has to be a guideline worksheet for every one of those scenarios, or it's going to get reversed if somebody takes an appeal. And so there could be 5, 6, 7, 2, 3, 4, however many worksheets attached to that agreement to support whatever that retroactive child support number was. The 5th District Court of Appeal case got reversed because the trial court didn't use the actual income for those periods of time. Modifications, we're not going to look at that statute that I just talked about because that's for initial actions, but a modification, you can amend, order a different amount of child support than what the final judgment provided, retroactive to the date of filing. So, petition to modify child supports filed January 1st, 2025, and you're mediating in March of 2025, the agreement can include a retroactive modification to January 1st. And then the credits, dollar for dollar credits need to be provided. If child support was being paid, even if it wasn't the full amount, whatever dollar was paid in child support, that person needs to be credited for during that arrearage period. Sometimes if child support's modified downward, they've paid too much. Or flip side of the coin is that they weren't paying enough because they continued to pay the amount they had been ordered to pay. And so there's going to be a calculation for the difference. So the new amount's going to go into effect. I think Mr. Rojas said this earlier, all your mediation agreements need to say, when does it commence? We get an agreement for child support of $432, but we don't know when it starts. So commencing March 15th, April 1st, guideline child support's X dollars. See the guideline calculation worksheet that's attached. And if if child support's gone up $20 a month, go add $20 a month times however many months have elapsed since that modification petition was filed, and get addressed with your parties. How's that going to be paid? The new guideline number is X plus so much a month until that arrearage is paid for the new amount. Anything else about that, Mr. Rojas?
Well, there is a question, but before that, a couple of things. So the 24 months is the maximum prior to the filing of that original petition. So when you see that petition for dissolution of marriage, the date of that filing, you may be able to go back 24 months, or that date of separation when the parties last resided together. And that's where your retroactive begins. And then you need to consider those circumstances. In regards to the modifications, make sure, and I don't know if you're able to get this, but the clerk can get a printout for many of these cases where the clerk is involved and give you an idea of what those arrearages are. So unless it's a direct pay case, in many of the cases, the clerk is keeping an accounting of those assessments, the amount of child support that's going on every month, and what are the actual arrearages, which is the amount that has accumulated since child support was established. And they may be able to print that for you, because many times at mediation, especially in supplemental petitions to modify child support, the mediators may not know they might have access to that if they contact the clerk of the court, that domestic support keeps an account of those. That's only in cases where there is an actual state disbursement unit payment. If it's a direct pay, they don't keep track of those. There's a question in regards to the mediator's responsibility under in underemployment situations. This is where where you can tell the party saying, well, I'm working part-time, and I'm making $18 an hour. Well, you know, and the way that I see this, and Judge Craggs, correct me, you may have a different point of view, is if they're working and making $18 an hour part-time, you know, the question to ask is there anything preventing you from working full-time? And there may be a good reason, and you know, maybe they're working 35 hours, and maybe that's kind of like a policy of that place of employment that they only employ for that amount of hours, to not give full-time benefits. Or maybe it is like that other situation where they're working at a restaurant and they're doing tips, and you're just not getting that information, where that party could be advised that, well, if you're not able to provide me with candid information about your actual income and we can run these guidelines, the court is required to inquire and impute median income, which is close to $60,000 a year. So, you know, how do you want to proceed in regards to this? So those are kind of the two extremes. You know, there might be a good situation or a good reason for not making the full-time amount that they were making in the past. There might be, but it requires just asking a few questions. Judge, is there anything you want to add in regards to that?
What I thought of are occupations that don't have 40-hour work weeks, firefighters, law enforcement officers, nurses. That's when you often see, you know, work schedules or number of hours worked that don't add up to 40. If it's a type of employment like that, where you generally have an understanding that is the common work schedule, then you know, that's a different situation versus somebody saying they're working 25 hours a week as a secretary or as a clerk in a store, or you know, something that probably doesn't have a 10-hour shift or PRN or 24 on, 48 off, those kinds of things, where it's they're not underemployed. That's the way that those professions have their work schedules. So you'll just use your good common sense there. If you have a party that has that kind of a situation and the other party's arguing they're underemployed, you know, as a mediator, maybe you try to address that in a more common sense type way.
So issues in mediated agreements, and I think you mentioned one of those, Judge, in regards to the lack of clarity about the payment schedule. So a very standard language is, you know, the obligation will assess at $400 some a month and will begin on next month on the first day. It seems pretty straightforward, but sometimes there's not the date when it will begin, or it doesn't state how often is it supposed to accrue, if it's monthly, bi-monthly, bi-weekly. And all of those things have a meaning, and it needs to be specific in that sense. Some people may want to pay every two weeks, and some people may want to pay 2 times a month, the semi-monthly payment. And that needs to be made very clear in the agreement, so that there's no confusion as far as the enforcement side.
I would add to that that the mediation agreement needs to clearly say whether the payments are going to be direct. There is a statutory provision that prefers payments through the child support disbursement unit. And so there is an analysis that's made. And oftentimes, if people don't want to get tangled up with the child support disbursement unit, they need to know, number one, they better keep very good track of their payments, because no one else like the clerk is going to be doing that. And number two, if they get behind on their payments, there's a policy and a provision that income deduction will go into effect and payment through the disbursement unit will go into effect, because the public policy is, we want child support to be paid, and we don't want contempt hearings when there's non-payment of child support, and we don't want people having to go on to or receive public assistance because one parent's not paying child support. So how they're going to pay it, what maybe some what ifs if payments fall behind. Another common thing that I see is the switching of the dependency exemption is conditioned upon the payor parent being current in their child support as of a specific point in time. You know, you have a payor that's behind, not paying the child support, and they want to claim the child as a dependent. So sometimes you see that provision that the dependency switching is conditioned upon being current in your child support. But I think maybe the most simple way to put it is, when somebody else picks up the mediation agreement and looks at it, can they tell when it starts, what the amount is, the frequency of the payment, where the payment is made, you know, those basic core things.
You know, another thing is parties may think that because they agree on an amount of child support, that that is not likely to be touched. And generally, that is the rule. However, when the Department of Revenue gets involved, or the state, because there's some public assistance or someone required their assistance, child support may be modified if it qualifies, otherwise qualifies under the guidelines. So whatever they write as to child support could also be modified in the future by the Department of Revenue. Sometimes parties are not aware of that. That is subject to review and modification, and they come surprise to hearings before me because, oh, well, now the mother is receiving public assistance, or the father. And
That applies across the board though, too. Not Mr. Rojas is 100% correct, but child support is always modifiable. So when parties want to agree that child support is X dollars and it cannot be modified, even if they agree to that, that is void against public policy, and it's not going to be approved, and it's not going to hold up. They're going to be, one party may be very alarmed when the other party figures that out and files a supplemental petition to modify child support to increase it, when the person who asked them to agree never to modify it gave away some things to get that deal, and then the other person bodes their time a little bit and then files the modification, because the parent isn't going to get to redo all the other things they agreed to, because those things do vest. Equitable distribution vests upon the moment the final judgment is entered. And so if you hear people talking about non-modifiable child support, there's no such thing.
And I think we cover many of these things, Judge, in regards to, for example, a month is not 4 weeks, is 4.333 weeks. Many times they come to me and they say, well, my income is $1,000 a week, so it's $4,000 a month. Well, really, it's not. It's $4,333 a month. And so make sure that, and this I can send to you, is shortcuts to very common calculations that you do on a regular basis, because they may give you the information of how much is it per week that they're making, or per hour, and you need to calculate the total amount. So it's not the same, like like Judge Craig said, you know, 24 times a year, which is every 2 times a month, or 26, which is every 2 weeks. Minimum wage in Florida keeps changing, and the median income is also updated from time to time. The most recent one I could find was from 2023, but that keeps changing. There might be one in 2025, so it needs to be checked. Also, in regards to school, and we talked about this, Judge, that there's like about 10 weeks of summer and 1 week of Christmas, or 2 weeks of Christmas break, 1 of spring break, and 39 weeks of school, about average. So sometimes when they're talking about overnights, you know, that 365 days, and I know the agreement and the mediated agreements is the dates are counted one by one. Those overnights are counted one by one. But as you're considering all of these things that, you know, they're going to be slightly different. It's not like if a parent has the child during the summer, that you can make an agreement that they're not going to pay child support during the summer. That's not how child support works. What happens is those 2 months out of the summer will be considered as overnights in the calculation, and then the child support amount for every month will be adjusted accordingly. So that's how that works. Any questions in regards to that or anything else we mentioned today?
What I would say about the counting the overnights, I think I do it a little differently. I mean, you can get the Marion County Public School calendar, or if they go to a private school, you can talk to the parties about, you know, do you have your child's school calendar? And but that is literally a process of 365 days a year. I usually say 70 days of summer. I usually say 18 days for Christmas. We, you know, we all have our kind of our ways of doing it, but and just go slow, you know, with your math. You know, you're going to end up then with what you call the regular time, you know, regular time sharing, school year time sharing. And if you have every other weekend, you know, is that 3 overnights? Is it 2 overnights? Is it Friday, Saturday? Is it Friday, Saturday, Sunday? But just, I'm sure you all have mediated enough that you probably have your own little tricks of the trade there when it comes to calculating overnights. But
Okay.
we'd be glad to open it up to questions.
Any questions? Anything we can
Question.
And if Marianne, if you could take away the presentation and put everybody back up on the screen, and maybe everyone can turn their cameras on if they're inclined to do so, especially if you're going to ask a question.
should be able to stop sharing right here.
Okay, thank you, Mr. Rojas.
I have a question. So I understand that you're wanting us to turn in the child support guidelines worksheets with our parenting plans and marital settlement agreements. Are we also required to figure out retroactive child support? Like, let's say there's a case that was, you know, filed 9 months ago and one party hasn't been paying any child support up to this time. Are we required to do that calculate that as well?
Well, I think the payee is entitled to child support from the date of filing forward, or if they've not lived in the same household with the child up to 24 months before that. If you ever have concerns, look at the pleadings, you know, and I've researched that issue. Do they have to plead for retroactive child support? And I think statutorily they're entitled to it. And so if they're not interested in that, you know, if the payee says, oh, I don't want retroactive child support, the other parent's been helping me do this, that, or the other, include that in the agreement that the parties are specifically waiving any retroactive child support because the other parent paid for all the summer camp, or the other parent paid 100% of uncovered medical and there was some big medical bills, or, you know, whatever it might be.
Got it. I also have another question.
Sure.
Attributing income, if there's a mom, I've had a number of these cases where there's a mom with a small infant and a couple of other children that are not part of the case that we're mediating. I mean, how do I determine if she should be working or it's okay for her to be staying at home with her children?
Well, really, it's going to be the other party that raises that issue. So if the other party is saying, "Hey, my kids with this person are in elementary school or middle school," and that and I think in your example, the mom has a new baby with another husband or person, and that's why she's not working, is because she's home taking care of this baby that isn't mine. That's a fair issue to be mediated. Is she voluntarily unemployed or underemployed? And um, is she willing to have income, is she willing to agree to have income imputed to her for the purpose of settling the case, with the other parent with the older kids? And this may sound silly to say, but I'll say it anyway. Imputing income doesn't mean the person has to go get a job. It just means child support's being calculated as if they were working, earning that income. I mean, I've had
Okay.
people say before, I have to go get a job. No, you don't have to go get a job, but your choice not to work is not going to be borne solely by the other parent of your older children. And there's some case law out there about that too. A lot of things are case specific, but from a mediation standpoint where you're just facilitating them trying to agree to it, I think the issues that are bantered about when trying to decide if these people can settle their cases, well, are you willing to have income imputed to you to calculate child support for the two older kids? And then the other thing that I would say that's not really related to your question is sometimes people think they know what the child support guidelines are going to be, and they think it's going to be about $500 or they think it's going to be about $200. And when you run them, it's not. And so sometimes before people kind of light their hair on fire, see what the number is. You may save yourself a lot of time, or the case may resolve unsettled sooner because they have a better idea. But just because somebody else is earning a lot more money, this is how I always tried to explain it, that drags the guideline child support number up. And your lower percentage of a higher amount might be more than your higher percentage of a lower amount. I mean, you have to run it to see what the answer is before you presume anything. So
There are some things that may seem nonsensical to the parties. For example, child care affects child support greatly. So a child that is not in school and they're paying $700 for childcare, that will balloon that payment for child support for that child until it's modified, because that will be established at that rate. And it will be greatly increased to what they may be thinking because of that. So
the removal of daycare is probably one of the most singularly monumental factors in a child support modification. It's like when your kids graduate college and come off the payroll, you're like, daycare is very expensive, and it drastically, you all probably all know that, changes child support. And guess what? When it gets modified, because the kids are all in school now, that number doesn't change until somebody files a supplemental petition. I
right.
don't know if that'll come up in your mediation, but when they're agonizing over how much child support is because of the daycare component, just remember that it's their burden and their responsibility to seek a modification.
So that's not something that we can also run a guideline for and say, once the child is no longer in daycare, this is what the support would be?
The case law has been, and it's changed, that's a prospective modification. And for a while, prospective modifications of anything were not permitted, especially with regard to time sharing, which is, I know, not exactly what you're asking, because you don't know, nobody has the crystal ball. And so, yeah, we all know that when a kid turns 6 or 5 or 6 and goes to kindergarten. But it's difficult to know whether there's going to be aftercare or not be aftercare. And so I'm not going to say a flat no, but it may not be the correct information.
Okay.
Mr. Rojas, what would you say?
Oh, absolutely. Well, the perspective, because the other thing that will happen is the parent's income may increase because because of inflation or other costs for the child may increase. So that's why the modification is incumbent upon the parents or the person paying specifically if they want to lower it, or the person receiving it if they want to increase it, to file something to have it modified, unless because otherwise it will remain the same.
Or the child doesn't get into aftercare, the public school system aftercare, because it was full, and so now they're doing karate.
Right.
Dojo picks them up in the van, and that's more. And or now they need before care because their new job, and it's you can tell we don't really like it. But
Okay. David, you have a question?
Yes, I do. I was just going to ask if it would be acceptable or appropriate, say you have some parties that the kids are just getting ready to go into school. So we know that 1 year of daycare is probably going to happen. Would the court find it acceptable as part of the agreement to say that the parties will, attempt to recalculate child support, when the child returns back to school? In other words, they know it's going to happen, and they're agreeable to recalculating or checking what the guidelines are or whatever. And if you say yes, what would be the appropriate way for them to submit that? Because we all know sometimes parties, just file something with the court, or they just do it on their own, but there's nothing documented. So then later on, they're trying to figure out, how much arrearages are. So is that something that they could potentially negotiate with the parties and help them try to figure out what to do in the next year or so if something's probably going to change quite a bit?
well, they certainly can say that they anticipate a change in 12 months, and they agree to sit down, they agree to exchange pay stubs with current year to date and current health insurance, and they agree to attempt to agree to a new child support number. But unless there's a judgment or an order entered that adopts it, then it would be wrong, for lack of a better way to put it, for them to think that that's all they need to do. And then 3 years down the road, there's a problem, and it's all being calculated based on the old number. And so it's always a good idea for there to be an order entered or a judgment entered. Now, Florida family law rules say that a modification cannot occur without a supplemental petition being filed. And so we do see people file joint stipulation to modify child support, and they send me a court order. Well, I really don't have the ability to say, oh yeah, no problem. You don't have to pay the clerk of the court their filing fee. I mean, who am I to say that the clerk of the court doesn't get their statutory filing fee that their whole budget is built off of? And so, I don't think that I can give a hard and fast answer. I mean, if they knew something was going to happen in a couple of months, I might feel one way, but where do you draw the line? And again, I have a problem, a blessing, an agreement that takes away the clerk of the court's filing fee. And I don't relish in saying to these people, oh, be putting your pennies in a jar because you're going to owe another $300, $400 to pay a filing fee. But the rule is no modification without a supplemental petition. And I can't sit here and say, oh, I'm okay at 2 months, but I'm not okay at 4.5 months, and that kind of thing. And so I know I'm hedging, and I am hedging. I'm not going to say I've never done it before, um, but it had to be a pretty unique set of circumstances. And, you know, we didn't pick when they filed for divorce, or we didn't pick when they filed the paternity case. And I'm not saying they should know that, but, I'm not going to endorse that they don't have to file a supplemental petition, but I do think they could very easily get together, run the new numbers, file a joint petition for modification, both sign it, both attach the worksheets. They got to file their affidavits again. So it is complicated. Well, it's cumbersome, and it just is. So,
Now,
Judge,
Judge, can it be dealt with? And that's one of the questions, as a step up or a step down, instead of, because, you know, sometimes it happens in the thing that we call the step down, that when the child that was in the custody of the father the majority of the time emancipates, now the obligation will go up for the dad substantially. So it's really a step up in some circumstances when you run the guidelines for that child left over. If there's a trigger and there's a specific date, August, 15th of 2026, they're going to start school. At that time, the obligation will reduce to 365 based on the current financial circumstance of the parties, and the parties agree to doing that. Would that be something appropriate? Because I have seen that in some agreements and treated as a step down.
well, and I guess I was focusing a little more narrowly on Debbie's example of the kids starting school, versus emancipating, which would, there is no problem at all with using the step down to change the child support number when the oldest child, or the second oldest, or whichever it is, emancipates. And it is true that the new number is based on the old income information and the old insurance information. But the fact that we have step down calculations doesn't mean there's not going to be a modification. I mean, to me, that's sort of maybe for a layperson or a pro se party, they may think, oh, there's this new number when the oldest child emancipates. I can't modify. It's already been determined. And I've often wondered, is there ever been a party that thought that they couldn't modify? I don't like that part of the step down. I mean, I think the step down was done because kids would emancipate and the parties would never seek a modification. And then they would come back and say, my God, my kids are 27 and 32 and, whatever it was. But I can't say I have a problem with the step down, but with Debbie's, where'd she go? Everybody keeps moving and I can't find them. But on Debbie's example, I don't really know that there's a way to cut the corner. And I don't mean that in a negative way, but
Judge, if you don't mind, would there be any instance, and I don't want to say just, never or rarely, but would it be acceptable in any way to calculate the child care outside of the true child support obligation, meaning child support is such and such, and they'll pay 75 and 25% of the child care, whatever it is. So
the
if it
statute
changes
doesn't
next year.
provide for that.
Okay, I'm asking because agreements, people can agree to do different things. And so, oftentimes our mediators are asked to do things that are not necessarily like pay child support till they're 21, or pay child support, or pay for their college expenses, which the court can't require them to do, but it's a contract, right? So that's why I'm asking.
Well, I guess let me think if or let me try to articulate if I understand what you're saying. Is like they say child support until May 31st of 2025 is X dollars, and included in that calculation is daycare of $700 a month. And then child support commencing June 1, 2025 is going to be X dollars, and it doesn't have the daycare expense in there because they know the kid is going to start kindergarten, in August. I think they can do that. And that reminds me of another point that I want to say that I don't think either of us touched on today is summer camp cost. And your aftercare expense through the public school system is during the school year, but what do they do in the summer? And do they need daycare in the summer? Is the kid going to Karateville or YMCA or for childcare expense, not necessarily extracurricular or enrichment? I mean, we're not saying that the kid going to sleepaway camp in North Carolina for 2 weeks, that's going to cost thousands and thousands of dollars is childcare. That's an enrichment thing. That's more of an extracurricular type activity. But just don't forget your summer childcare expense. And if it's for 10 weeks, you take that number and then you take your school year childcare expense for the other weeks of the year, 42 weeks, and maybe it's just 40 because we back out 2 weeks of Christmas, whatever you're going to do, and then add them all together and divide by 12 so that you have the same amount of child support all the different months.
Mary Ann,
Judge,
you have a question?
Yes, I do. The first question I have is really a simple one. I just had a sound glitch as you were saying it when you were using your acronym for peace. The first E was equitable, and then I didn't hear that after that. Could you say that again?
And peace is parenting, equitable distribution, alimony, if any, child support, and E is everything else. Dependency exemptions, switching them, attorney's fees. E is just everything else, but that's what peace is. Parenting,
Okay.
equitable distribution, and in that order.
Okay, thank you so much. I missed that. My other question goes back to something you were saying shortly after you started, and that was you were talking about if child support is not in the pleading, then you can't deal with it later. They need to put that in the pleading. In mediation, as you know, people bring up all kinds of things that are not in the pleading. All of a sudden there's family dogs we have to talk about or whatever. If they bring up child support, should we not include that to say, and they say it wasn't, I'm just didn't bring this up before, I'm bringing it up now. Should we not include it or?
Okay, two things. One, dogs are personal property, so that's
Right.
part of equitable distribution.
Correct.
Furniture, poodle, Nissan Altima, whatever.
Right.
And as far as if they didn't plead it, let me try to answer your question this way. It could not be in the pleadings, but it's tried by consent in the courtroom. People
Okay.
come to court. Let's just use your example. They're talking about child support and the other person never objects. And then that person starts talking about child support, and there is a legal principle of that the issue was tried by consent. And so the person who never objected and went along with it or just never said anything can't file an appeal and say they never pled for child support because you sat there and you let them run with it, and now you can't come back later and say gotcha. So if they want to talk about child support and you've reviewed the court file and there's no petition or counter petition requesting child support, first of all, I don't know if you're caucusing separately at that moment. I don't know if you're in a joint session at that moment, but I think you can raise the issue of to the petitioner, especially if that's who's asking and you're in a private caucus of, did you ask for child support in your petition? Did you plead that? And if they didn't, and the other side is saying, whoa, 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 I didn't know we were going to talk about that, then, the issue has become apparent, and the petitioner can say, hey, look, okay, we can quit mediating. And then I'm gonna file a motion to modify or amend my petition to seek child support, and the judge is gonna grant that because amendments to pleadings are freely given, especially child support, something that's for the benefit of the child. Or we can agree in this mediation agreement that, yes, I didn't plead it, but you're gonna waive that, and we both agree that we need child support to be determined. And so I think you're gonna have to read the room for a minute. I mean, I don't know that if you're aware that it hasn't been pled, and nobody else is, you may have to have a private caucus with your petitioner to bring that up. I don't know that you can do that in front of the respondent, or the other person. And if it really is something that's not bothering either one of them and they overlooked it or what have you, I think it's easily curable. But if it's a problem and the other person is like, hey, you didn't plead it and I'm not going to sit here and talk about it, one, I think you can caucus with them and say, you guys have a kid or two kids or whatever, and if you think child support's not going to be addressed and the pleadings are not going to be amended to include child support, you're just, that's probably slim to none, that it's not going to be permitted, ultimately permitted. And if they don't ask for it until now, then I don't know it going back. Well, there's a statute that says that the judge can go back 24 months, or less if you were cohabitating as a family with the child. And, that may sound like a great idea, but it's probably not going to have a long life.
Okay, thank you for clarifying.
I
Ms.
just would
Waterman,
approach it from a practical standpoint. I'm sorry, go ahead.
Judge Cracks, I cannot talk about mediation a whole lot because other than participating in a lot of mediations, I'd never led some mediations, but your experience with that's just amazing with your insight. So, Ms. Waterman, you had a question?
Yes, but I think it was answered. I've had attorneys, and oftentimes it's where one side is represented and the other is pro se, that will say, the DOR there's already a DOR order. Child support cannot be changed. We're in a paternity case, and I don't know what the pleadings say. But I think what you're saying is child support can always be modified, even though there may be a child support order in effect through the DOR. If the case now has there's a paternity case pending, and child support is an issue in mediation, I think it can be addressed, as Judge Craig's just kind of explained, right?
Well, yes, but it does. I mean, it does. And if you have an attorney involved, and I mean, it maybe they know that it wasn't pled, and they're not going to waive it, and they're not going to they're going to tell you not to tell the other side that. They don't want the other side clued in on that. And so sometimes you're going to have to deal with that situation where, as the neutral, impartial mediator, with an attorney involved who is telling you, I don't want that. I don't want the other side to know that. That may hamstring you a little bit. And I think as a mediator, you can raise the issue of, well, do you think that's going to have a long shelf life? Or do you think that that's ultimately going to come back in front of the judge, and the delay and the additional expense to both clients, yours, and is that really what we want to do? And they may say, absolutely, that's what we want to do. And, you may feel like, gosh, my chances of trying to help these people settle this case just went down, drastically. But one point that I thought of when Ms. Waterman, when you were talking is, and I'd like Mr. Rojas to address it briefly, is administrative child support, or, child support's been determined by an administrative order, or there's been a petition filed by the department, and superseding orders. And, oftentimes I'll get orders from Mr. Rojas where he has had to tell the parties, I can't hear this case because there's never been a petition filed to change child support. And Mr. Rojas does such a great job because the Department of Revenue cases, man, they have a lot of intricacies that are very unique just to the Department of Revenue cases. And so, Mr. Rojas, could you touch on that briefly?
So one of the things with DOR cases that I've seen that mediators do is that duty to disclose. So as you bring that to the attention of the parties, hey, child support, and they bring to your attention that there's a DOR case that we cannot or, will not address, just the fact that you put that in the mediation, the parties acknowledge that there's a DOR case, Department of Revenue case number so-and-so, and that anything regarding the modification of child support will be addressed in that case by the parties. I've seen that provision put in mediation agreements, and that's very helpful. Also if it's two judicial cases, the judges, the family law judges are pretty good about referring the child support portion of the case to me if that is brought to their attention. So Judge Crax refers that portion to me in that other case. If the parties brought that to their attention, what happens is DOR needs to have separate notice of that hearing. They need to bring information to the table of money that may be owed to the state. So there's a lot of moving parts in those cases. And sometimes the easiest way to handle those is that the judges just refer those matters to me and I address them. It doesn't take more than 30 days. Well, it takes between 30 and 45 days for me to schedule those hearings after it's been referred to me. But it doesn't take long if it's brought to the attention of the judge that they're wanting that child support obligation reviewed based on the current time sharing that they're involved in. So it's not just because that child support case is not in front of you, it doesn't mean that it could not be addressed in the future if the parties bring that very clearly to the judge's attention, because the judges may refer that matter to me if it's clearly pled. Of course, if there's an attorney that makes things easier, they'll know exactly all of the things to file. But under the unified family, system that we have, really the judge assigned to the case has the authority to refer all matters on that case to the hearing officer, general magistrates that may be addressing specific matters. And Judge, anything in regards to that? At mediation, they're not curtailed from, they may not be able to establish or run guidelines in those DOR cases, but at least to address it, notify it, and let the judge know that there's that separate case that they're.
If the parties want to do that, then I think I agree with Mr. Rojas that they can just simply say, because I'm going to be looking for the child support. Where'd they talk about child support? What'd they agree about on child support? But if they say that they're going to, settle their parenting plan and whatever all else, and then they're going to go back in front of the child support hearing officer to modify child support based on this new parenting plan or what have you, that's perfectly fine. If the Department of Revenue files a motion in the case I have asking that the child support issue be pulled, if you will, and put back in front of the child support hearing officer, unless there's a well-taken objection, I grant that pretty much every single time, because I know that Mr. Rojas knows that case frontward and backward. And frankly, the Department of Revenue has considerable additional resources to me to go into their databases and find the income. And I mean, they can access all kinds of financial income information for parties. And so I am not, because I don't want to do it, but I don't want to inadvertently mess up the Department of Revenue's child support case that's been pending in front of Mr. Rojas in years past. And I like to send it back to him because I really think it's the best thing for the case for consistency. And I'm not going to know that mom is getting, I may not know, and they may not tell you as mediators that they're receiving food stamps, or which doesn't go into child support, but that they're not, but that the state of Florida has an interest in this, finding out about this child support. You may not know that. I may not know that. Mr. Rojas is going to know that because the Department of Revenue's computer, they're, I jokingly sometimes say big brother, but they know exactly what benefits are being paid, how much they are. They know the person's employment income information. I wish I had access to all that.
In-state, out-of-state, veterans
It
benefits.
would really cut down on less than candid information and testimony. I would love that. But Ms. Waterman, if your base question is, if an attorney tells you that child support cannot be modified, that is not true.
But that it can be modified by going back to the DOR, absolutely.
Yes, and I'm not saying that they can't file a supplemental petition to modify child support, not through the Department of Revenue. They can do that, but there is no, and they're not bound to them till death do they part or something like that. It might be the best way to do it, but they're not. There's no black letter rule about that.
Thank
And I
you.
see that Debbie Clark mentioned in regards to the sharing of expenses for childcare. If the parties agree to share the expenses of childcare, if that could be separated like they do uncover medical expenses, like they do some of those things, uncover medical expenses. I'm thinking also of extracurricular activities, school costs. The thing is that the statute doesn't really provide for that. It really provides for the expense for the children and who's paying it actually.
Are you talking about daycare?
I'm talking about daycare, yes.
Yeah.
Yeah, I
So-
was trying to add on to
Well,
what I was saying
but
before, Judge.
if they have 50-50 time sharing and I pay daycare my week and the other parent pays daycare his week, you can, the calculation program allows, you can put under mom, she pays $500 a month and dad pays $500 a month. But I mean, the most accurate child support calculation is going to have the 500 on each side, not zero, because,
Right.
it's a wash. I mean,
I was just, Judge, trying to go back on what we were talking about before. Instead of, it's trying to
you're not going
anticipate,
to let it
but
go,
not.
are you, Miss Clark?
Well, I'm just trying to be clear on what I was asking you, Judge, and I don't think I was clear. And I think when you added like the summer, that kind of stuff that you don't anticipate, you don't know what the prices are, that would be a good example of being able to do the pro rata share on
Or
that.
they can agree that last year YMCA was $125 a week or
Mhm.
whatever it was, and they can base this year on that. There's nothing to
Mhm.
say that there's going to be an audit that says, oh no, YMCA was 135 this year and your whole calculation is wrong. If they don't come to mediation prepared with the information that they need, then they can do the best that they can and use the most current recent information that they have. And that's not going to really cause the whole calculation to be thrown out or anything along those lines. I mean, ideally, they're thinking ahead and they're like, well, I know we're going to have summer camp and shoot. They could say Boys and Girls Club is 110 a week, YMCA is 125 a week. Karateville is X dollars a week. We don't know what we're going to do this summer, but if you average all those together, this is a good number, and this is what we feel comfortable using. Because mediation is, they have flexibility. I guess I'll mention that too. The beauty of settling at mediation is they can do things that I can't do. And so they have to gauge how important it is to them, whatever it is, whatever that important issue or two or three is. You know, you as mediators, I guess you pose the question of, well, do you think that the judge has the ability to do that if you don't settle today and you go to trial? Do you think the judge can do that? Well, we don't know, you know. Well, okay. But flexibility is got to be one of the top benefits of mediation, and settling at mediation is, you know, you can agree at mediation, this doesn't have anything to do with child support, but you know, that they're going to wear yellow on Monday and purple on Tuesday. And I can't do that. But it depends on, you know, how important it is to them, and the big scheme of negotiation.
Well, and Judge, one thing is what's been happening, which may be counted towards deductions and credit. So for example, the non-custodial parent is paying for healthcare costs for that child. Even though he's the non-custodial parent, his insurance is better, he's been paying for it, he will get the credit. And if he's in reality paying for the child care, that will need to be made clear in the agreement, because all of those things will affect the calculation of child support, you know, as the parties are doing it now. If he's paying the $500 for, you know, childcare for the child right now, it will go in his credit, but that will need to be clarified in the mediated agreement. So sometimes they do that. It's not the usual thing you see, just like you don't see the non-custodial parent generally paying for health insurance for the child that is in the custody of the other parent. But you do from time to time see that being the actual thing that the parties are doing.
And to me, that's just as simple as, where do you plug that into your child support calculation program? I mean, if I've heard a case, my findings are going to be the petitioner's gross income is X dollars, and I'm going to cite to the evidence that I base that on, or the testimony. And then it's going to say something like, the petitioner's deductions from gross income pursuant to 61.30, whatever, are health insurance for the petitioner, mandatory union dues. I mean, I have to set out, and then hopefully when you look at the guideline child support calculation worksheet, it's all going to match up, same, you know. But it makes no difference at all to me who's paying the health insurance for the child, who's paying the daycare for the child, or if they're splitting the daycare because it goes into the program. It's it's as simple as, which column do you put it in? And it doesn't matter to me. You know, the non-custodial parent may have health insurance available to them through their employment at a reasonable cost, and the payee, the custodial parent, doesn't have health insurance. You know, and I think that's another thing I'll say is if the child has Medicaid, and one of the parents or both of the parents have Medicaid, just put that in there at no cost to them. So I know they do have health insurance. It's just no cost, and it's through Medicaid. Just one simple sentence. And then like in my brain, I'm like, okay, check, there's the health insurance component. Or they have Florida Kid Care at $25 a month, or whatever it may be, or $25 per child per month, whatever it may be. I know there's some tricky things about what's income and what's to be deducted, and especially if you get into disability and things like that. But you know, a more garden variety case where you two W-2s, I mean, and they bring in their health insurance information that shows if they're a single person with no dependents, their health insurance is $25 a month. And then if it's employee family, and I'm sure you all are pretty adept at this, and you just get really excited inside when you have two W-2 people who know their health insurance cost and their daycare cost. I mean, yes.
Yes, they're ready with all their information.
Mhm.
Well, I don't think there's anything else from the presentation that I have to add, Judge. Is there anything that
Not for
you wanna
me, and
say?
it's 4 o'clock on the dot, and Mr. Rojas is a organized kind of guy like that, so, I appreciate Mary Ann being asked to do it, and I appreciate Mr. Rojas even more at the conclusion of the presentation than I did at the beginning for all his help.
Well, and Judge, I'll send you what I told you that I would send to them. So if you want to add that to some of the materials and you can forward those to, because I know you have some things I don't have, and I'll
Yes,
forward
and
you
we'll get them
those.
to you, Mary Ann, so that you can just share them.
Okay.
All right.
I appreciate both of you presenting. I know I learned bunches, and I think our mediators did too. I know how valuable your time is, and I really appreciate you doing
Well,
this.
we enjoy doing things like this, and it helps us as well. So we benefit from it. And it's also nice to put faces with names. I mean, I see quite a few mediation reports, and so oh, there, so it's very nice to meet you all, so to speak. And thank you for serving, because mediation is just an integral part of what we do. So thank you all very much.
And just like you said, Judge, in many cases, I do see that the mediators are really trying to put their time and put those details in their mediator agreements. And it's just so very helpful when we get those cases. And so we do appreciate all that you do. I also wanted to thank them for that. So
All right. Have a
Thank
good
you.
rest of the afternoon.
thank you.
Thank you.
Judge.
Thank
Bye-bye.
you.
Much.
Thank you both.